watching what unfolded last week for me was disappointing. I totally trust the Deputy Mayor in my absence to manage the business of council, and I stand by the way in which that was managed, and I was disappointed at what I consider to be really quite a sideshow from the business of council. And the other point that I want to make is that at the pre-briefings, it is incumbent on the chair or myself, if it's a council meeting, to decide which matters go into public and which matters go into confidential, because they are appraised of the full information of the meetings. And I think it's up to councillors, all of us really, to trust that the chair makes that decision based on the information that the executive give before them. And it's not for councillors to comment on whether or not prior to a meeting an item should be in public or in confidential, in my view. So we're now reconvening. We don't need a prayer, and I call for apologies and ask for a mover and a seconder that the apology from Councillor Sarank be accepted. Thank you. Thank you, Councillor Donaldson. Seconded, Councillor Gould. All in favour, please say aye. Contrary? Carried. Thank you. Are there any declarations of interest? Councillor Gould.
Madam Chair, I want to ask two questions in the urgent business section. So I'm declaring myself as the CBD retailer and a resident of Eastside.
Thank you. For that, now we'll move to items of urgent business. Are there any items of urgent business? Councillor Gould, as you spoke first, and then Councillor Kent.
Thank you, Madam Chair. The lumber cube issue, can we please have an update at some stage of this meeting, because today is the 31st of May, and we have told the residents that the specialists will be giving advice to the council. And the other issue is about the CBD. What is happening with the contract? Can we please be informed as councillors so that we are aware what the timeline factor for that particular development will be?
The O&M, that matters in the, and you've all got your papers for O&M, so we'll park that till next week when we'll have that good discussion. Lumber Cube, I think we've made it very aware and very public. It was, I read it myself, that we've received the report. That's going through our legal counsel and our technical staff about the noise reduction strategy, and that will be made public next week. So we really have nothing else to add. Right, yes.
Worship, with regard to your comment then, I think some of us would be interested as to the rationale behind the council's decision not to communicate information that they requested through the OIA.
To the
official information process, did they not request information?
Who's they? Sorry, Councillor Kent.
Leading the fight out there.
Yes, did they what?
Did they not request further information, which the council turned them down? I'd be interested to learn what rationale was it. Why did we turn down their request?
Aspect.
So I believe the report that you're referring to was a report from Malcolm Hunt made available to council, and that was done on the basis to provide us with advice as to how we would proceed if we were actually taking a legal approach to this. That was advice received through our legal channels, and therefore is actually legally privileged. We would not make that available at this point, because it actually contains information as to how council will approach this issue if we chose to go down a legal challenge track.
Oh, sorry, Councillor. Oh, and Councillor Kent. Councillor Kent first, then Councillor Stewart.
Thank you, Your Worship. I have three issues to raise, one of which has just been touched on. The first one is the issue of our so-called live streaming, which doesn't seem to be. Last Thursday, for example, the live streaming started precisely 10 minutes into the meeting. And I would perhaps like an explanation. This is not the first time this has happened, and perhaps we can have confirmation that the live streaming is actually streaming live. Certainly.
Una. I do see Mary Ann pressing a button dead on 9:30 this morning, so
So, councillors, yes, we do live stream. The last couple of meetings we have had some technical issues which have meant that the live streaming hasn't started bang on 9:30. The council meeting on the 26th of May, I was told, started at 9:35, just looking at Mary Ann over there. In the knowledge that we knew we were having a few technical issues, we have also been bringing the camera in to ensure that we do have the footage and are able to put that up directly.
item.
Well, thank you for that explanation, but I do point out that the footage that is on the website starts 10 minutes into the meeting, so they haven't posted whatever was done with the second camera. The second issue is relating to Lumbercube. My understanding is that under the Official Information Act, the actual readings taken by council have been requested, but have been refused on the basis of legal privilege. It's my understanding that those figures are not legally privileged, and perhaps we could take the opportunity with Mr. Mackenzie here to have an explanation as to what is and what is not legal privilege in terms of that information.
Ask the CEO to respond to that. That's not a question. We don't bring legal counsel in on items other than we ask them to come to speak to us on, but if you'd speak to the item.
So all of the matters that we're dealing with Lumbercube are actually going through our legal channels, Tompkins Wake. So anything pertaining, in discussion with Tompkins Wake, anything pertaining to information which we may use as a later date with regards to Environment Court action is by nature legally privileged.
It was my understanding that it's actually the communications with the lawyers that is legally privileged, not actually the figures that have been taken with public funds.
And your third point.
My third point relates to a breach of the Code of Conduct and of the election protocols by the Deputy Mayor. I wish that put on today's agenda for discussion, please.
I'm going to rule that out of order, in that the responsibility of the chair of the meeting is to make rulings, and I understand that that's exactly what happened, and that is the role of the chair of a meeting.
Your Worship, it has nothing to do with the meeting. This is to do with the press release that was put out by council staff in Deputy Donaldson's name, which is in breach of the Code of Conduct and in breach of the election protocols adopted by this council.
Do you want to speak? Yeah. Right, we've had a discussion, which is right, and I've taken advice. This is not deemed urgent business. It's a matter raised quite legitimately by a councillor, and should be taken through the usual channels, which are those of the Chief Executive. Thank you.
Thank you, Your Worship.
Madam Chair, last week on the 26th of May 2016 at 9:30, council meeting was called. At the front of each agenda, and I'll refer to page 2, there is the reasons for passing this resolution in relation to each matter and the grounds under the section that, and the reasoning why that particular matter has to be held confidential. I see that as core business of this council. I certainly don't see it as rubber stamping. And I actually want an apology from Councillor McVicker, Councillor Bentley and Councillor Kent for their, as quoted in the newspaper, their boycotting that meeting last week on the grounds that it is an inconvenience not only the lawyer that was here to give a submission, but all the staff and us who did attend that meeting. And I expect an apology. Today's agenda is exactly the same as last week. So they're here to rubber stamp again, are they? And, Madam Chair, we made a considered decision that no committee has the right to make decisions, that all decisions must go through full council. That was as a result of the appointment of the two Te Arawa representatives to our two standing committees, and will probably concur after the next election when the two members of the Lakes Board, as recommended by the Electoral Commission, made the suggestion that we do that. So, Madam Chair, I expect those three who are here with the same agenda as last week. The mere fact that I believe they took an opportunity whilst you were out of the country, Councillor Webber and Councillor Maxwell, and you two on council business promoting this town, took an opportunity to try and embarrass this council and to have a perception that we were dysfunctional. And I expect an apology. Stand each of you and apologise to the rest of us, because you wasted nearly a half a day of our busy schedules. And I expect that to occur, Madam Chair.
Thank you. Well, that is on the public record. I did cover at the beginning of the meeting that it is the prerogative of the chair to decide which matters are in public and which are in confidential, and we as councillors must all trust that, because we're not privy to the information that we're given by the executive as to what is behind each matter. Any member has the right to call for an apology, and then it's up to those members whether they wish to take advantage of that request for an apology. Do any of those that took that position last week wish to apologise to this council? Councillor McVicker.
I'd just like to say, par for the course from Councillor Sturt, I will not be apologising. I think we three stood collectively to make a point which has been well viewed in the media, and I think it hopefully will have got the message through that we need to have more content, more issues in the public section rather than what we are seeing like today or last Thursday in the confidential sections. I think the public have had enough of issues that are conveniently put in the confidential section for whatever reason, and I understand the justification in many cases, but I believe we're going a bit too far, and I think we three represented the views that people were saying, and we made a stand, and I will not be apologising to anyone over the issue, because we believed in what we were doing once again.
Yes.
Vicar, which one of the 5 items didn't need to be in confidential? And can I ask the Chief Executive, if we didn't hold them in confidential, would we be in breach of the Local Government Act because we didn't act in accordance with the law of this country?
Councillors, I think we have previously gone through the rationale for why these items have actually been in confidence. I think the three really have got very different issues pertaining to them. Some of those are around legal process, some of those are around disclosing information about individuals and suitability for roles, and then the third is around the awarding of a contract, which has got a whole range of commercial issues associated with it.
Donaldson.
Thank you, Your Worship. I don't wish to comment on any matters of conduct because I consider myself on notice for a breach, so I'd be a bit conflicted if I did. But what I do want to say about whether an item is in confidential or not in confidential, that is a democratic vote by the members present at every meeting. So we all vote, it's democracy, whether items remain in confidence or we bring them out of them. So it's democracy in action, and we can vote on anything on this agenda to be brought out of confidence or remain in confidence.
There appear to be no apologies forthcoming. Councillor Webber, did you wish to add something?
Yeah, if you don't mind, Madam Chair. As you're aware, I wasn't here like yourself. I was visiting my very old and not well father for a week, and I was really disappointed because it just seemed to me that the things that were boycotted on are actually matters that have been raised numerous times in the past. And it appeared to me that for some odd reason, just because there were few, they decided to do this. And it just seemed very disappointing that the ratepayers couldn't trust our council to get on with what they have elected and paid us to do, and which most of us have done for a number of years. And it seemed that people didn't deem it worthy, and I've heard that said many times in the past by these very same councillors. It's not worth my time. We know time is precious, but the reality is we are elected and paid to do a job, and I think it's incumbent on us to turn up and do the job and do the work there. So it's nothing new that has been brought up by these councillors in the past, and I just see it as just really grandstanding. And the reality is that most things in confidence come out if they're deemed that they should in due course. That's normal. It's a big fuss about nothing. Thank you.
Thank you, Councillor Weber. I think you've summed it up. My view externally was that it was a political stunt, and it's up to the community to decide whether or not that this was good use of council resources, time, legal advice, and that's something that I will not judge myself. The community will decide. Councillor Maxwell, you had something you wished to add?
Kia ora koutou katoa, ni hao, za shang hao. All I want to say is also, like Councillor Webb, was very disappointed to hear what went on last week, and that 3 councillors chose not to be here for their reasons, and disappointed that they're not big enough and enough to stand up and apologise, but nor that, we're back here again, costing the ratepayers more money. But what I do want to say is that having caught up with some of the publicity and some of the news, that I take my hat off to the Deputy Mayor for the strong stand that he took. It wasn't easy, and you have my 100% support in everything that you did. And to the other councillors that did turn up to carry on. I've never actually, I read where 2008 was the only other time where there was no quorum. But in all the long time that I've been on council, we've never had that situation happen. And that doesn't look well for us. And but it makes me wonder, did they want to take advantage while they knew that some were away on council business and legitimate leave? I think that's what happened. But I must say that I've had a few ratepayers have spoken to me since. They're really up in arms about it, but you know, they'll express it in their own way. But I would like to take the opportunity to tell my colleagues that at last week's international conference for approximately 2,000 delegates from all around the world, you would have been proud of our mayor, who was a keynote speaker, who stood up and spoke and then joined the panel afterwards. And the questions that came from the international MC, who came from the USA, she brought some questions back to New Zealand again to our mayor, and they were and to me they were showing how much they appreciated the content of what we were promoting. Here we were promoting a little city like Rotorua that probably many of the 2,000 odd delegates would not have known, and our mayor was trying hard to promote us. And back home here we had some people playing silly games, but we were very proud of our mayor who did it. And straight after that important session on the first day, television cameras were around interviewing our mayor for that. But so for the record, I was very proud that I was present to see our mayor do a fine job for us. Kia ora koutou.
Thank you. That's a very good point, in which we'll move on, and I'll move now to the item 5, the confirmation of council minutes. On page 6, a mover and a seconder. Thank you, Councillor Hunt. That the minutes of the council meeting held on the 28th of April be confirmed as a true and correct record. All those in favour, please say aye. Contrary? Carried. I just wish to add in here, in terms of matters arising from those minutes of the 28th of April, I'm tabling at this meeting the 2 response letters that were sent to Councillor Kent in regard to his tabling of the financial spreadsheet. The responses, you've all received them, all councillors have received them, and I table them today in order that there is a true and accurate and transparent record for the council records. Once they're tabled, they're available, so they're the letters of the 13th of May and the 19th of May. I duly table those. Okay. Now, the next item before... Oh, sorry, Councillor Donaldson.
Yes, just one other matter arising from the minutes. I just wonder if the record should note, Your Worship, on page 7, that Rosemary Viskovich and a Tiara representative, that we are not now seeking that external funding. That's my understanding. Okay. All right.
Thank you, Madam Chair. Since you're tabling the responses from the Chief Executive to my tabling the spreadsheet, I assume that you're also tabling my response to the Chief Executive, so that this council actually has the full picture and not just what you want it to see?
All I'm doing is tabling the 2 letters today. Thank you.
Page 7. Councillor Hunt and Councillor Webber, have they confirmed their availability to represent us at the local government conference coming up shortly? Okay, thank you.
Week, you have considered, or the firm has considered, to waive. And I really appreciate that gesture. I only learnt about that this morning and don't want to embarrass you, but that was an aspect of concern to me, that when we had a full council meeting with legal counsel present, that was going to be yet again a cost to council. So thank you for coming, and if you could, I'd rather hear from on this item of business, yeah, and then yes.
Can a copy of that please be given to the press so they can understand when it's going through?
We'll make the decision when we've gone into public excluded. We'll wrap up the whole aspect of how we'll handle this report.
The submission made by council to Western Bay is actually a public
Yep.
document already in
So
front of
keen. Yeah. So the
Thank you, Your Worship. I just wish to applaud that decision, because that's what we were seeking, is to have matters which should be heard in public.
Councillor Kent, that's another cheap shot. Our submission to Western Bay is on the public record. The aspect that is in private today is our response, and that remains in private and in confidential, so you have achieved no gain at all. And we move now again to hear from our legal counsel. Thank you, Lachlan.
Thank you, Your Worship, and good morning, councillors. Yes, what I had intended to do was provide you with a public briefing on all of the matters that are currently within the public domain, leading up to the decision that has been made by Western Bay District Council. But at that point, when we move to discuss your next move and your strategy in terms of how you might respond to the decision, my recommendation would be that you have that discussion in public excluded. So, dealing with the matters that are within the public domain, I think first of all, just to remind ourselves of the context, we're talking about the Rangiuru Business Park, which is a 240 hectare mixed-use industrial development at Rangiuru, sitting within the Western Bay District. It's a land use framework which is already embedded in the Western Bay District Plan, and it was a land use proposal that was originally sanctioned by the Smart Growth sub-regional strategy many years ago now. The problem, however, that gave rise to this plan change was that the principal landowner within the plan change area, which is Quayside Holdings Limited. Quayside is the council-controlled organisation for Western Bay Bay of Plenty Regional Council. Their concern was that the existing planning framework was not giving them the platform to launch from. They saw significant infrastructural constraints and costs up front, which were holding back development. So they initiated Plan Change 72 to make changes to this planning framework to better enable development to get away. And there were a range of changes that they needed, but there were three that were of particular interest and concern to Rotorua Lakes Council. The first was a transportation infrastructure change. The original planning framework had a four-legged interchange off the eastern arterial into Rangiuru, which enabled very good connectivity both north and south, and obviously good connectivity between Rotorua and the Rangiuru Business Park. The plan change sought to change that connection to a three-legged interchange, and the leg that was lost was the one that connected up Rotorua in a good and efficient way. So there was concern about the loss of the four-legged interchange and the move to the three-legged interchange. Quayside, I think, gave evidence that the change would shave off at least $1 million in infrastructure costs from their perspective, but of course the concern from Rotorua's perspective was that it would lose an important level of connectivity in terms of the transport network. So that was an issue that we objected to on your behalf. The second issue that was of concern was increased flexibility around how the plan change area dealt with ancillary offices. So we're talking about offices which are attached or related to the principal industrial development. And as we know, typically within industrial areas there'll be a primary industrial use, and there might be some ancillary office space which is attached to the primary use. The plan change sought to decouple the co-location element of that so that they could locate their offices anywhere within the plan change area, including within an area called a community facilities area, which is the sort of central hub for offices. And there were concerns from our perspective about what that might do in terms of driving additional office development into those central hub areas. So that was the second issue. And then the third issue, which is linked to that, was that these central hub areas of office and retail use were designed to be sufficiently sized to meet the localised needs of the business park area. So there was provision made for offices and retail in the original plan that was embedded in the Western Bay plan. But the plan change sought to split the single area into two, and to make it more developable, and it also it didn't have any caps, so there were no upper levels or upper limits to how much retail and how much office space could be developed within these areas. The concern that that we'd identified on your behalf was that the potential development opportunity for offices in particular was very significant. We did some basic modelling with external planning consultants, Boffa Miskell, and they indicated very easily that you could get at least 20,000 square metres of gross floor area of office activity, which would have made it a very significant office hub within the Western Bay. Just to put that into context, the total gross floor area of offices in Te Puke, which is the most co-located or close centre, is 3,000 square metres. So that gives you a sense of the potential scale. And of course, if you think about a potential office hub at that scale, you can start to think about the potential impacts that might have on other centres within the region, like Te Puke, but also like Rotorua City, for example, or Central. So those three issues were the central concerns that were identified in the submission. I presented legal submissions at the hearing on the 18th of April, and we also had evidence presented by Peter Hall, the independent planning consultant from Boffa Miskell. We got a good hearing, and it was a very useful discussion that we had with the hearing committee. The decision was released in mid-May by Western Bay District Council, and to put in a short and succinct way, we got 2 out of 3. So the transportation issue that we were concerned with, we were successful with. So they have reverted to the 4-legged interchange. So we're satisfied with that as an outcome. The issue that we were concerned about in terms of ensuring the co-location of the ancillary offices to the primary use has been adopted, and they've introduced changes to ensure that if you are to be an ancillary office, you need to be either on that lot or on the adjacent lot. So we're happy with that as an outcome. But the attempt that we had made to create the caps on the total amount of gross floor area within those community facility areas, they have not adopted. Instead, I think they've taken comfort in the fact that the total the total footprint of the community facility areas is 2.6 hectares, and they consider that that of itself is sufficient to constrain the level of development for office and retail. So that means that those concerns we had about the potential office and retail development remains, and that's really an issue that needs some further discussion and debate as we decide what our next steps might be. Just to frame that up, the appeal period concludes on the 28th of June. So if there is to be an appeal, if you are dissatisfied with the decision, obviously the remedy is lodging an appeal in the Environment Court, and that would need to occur before the 28th of June. And as I said, we can explore whether or not that's a sensible option to pursue, but my recommendation would be that that discussion will involve some legal strategy and some legal advice, and would be best held in public excluded.
So to protect, we could take questions, but we have to be careful that we're not making consideration. So questions for clarification. Councillor Stewart.
For your report, and I appreciate the fact that you're not charging us for last week. I'm delighted. Just in terms of the community facility comment that you made about the 2.6 hectares, you said that, and I quote, they believed that the actual area of 2.6 hectares actually constrains the development because of that size. In today's environment, yes, but what about into the future? I mean, if it's there, it has the potential for a mini Te Puke, if you like. So I just wondered, was that traversed in terms of Boffa Maskell and your own submission in terms of that?
Yes, it was. I mean, so the 2.6 hectares is the total amount of land which has been allocated for these community facility areas within the overall plan change area. But there aren't sufficient constraints, for example, on how many levels can be developed within the footprint of 2.6 hectares. So Boffa's did some basic modelling. There are some car parking requirements which constrain the level of development, but factoring in some of the car parking requirements, Boffa's produced an example of a model of what could be developed in the community facility areas at 2 levels. And that was where they had produced the 20,000 square metres of potential office space. And you know, look, there's a number of iterations and designs that could be created, but that just gave an example of the level of development that might occur without caps.
Thank you, Worship. Through you, Lachlan, just in terms of the time frame, you've mentioned the cut-off by the 28th of June. What's a realistic time you would need to prepare if the decision was to proceed with an appeal to the Environment Court?
Well, we often work under pressure, so I'm used to working against a deadline. But I mean, it would be helpful if there was some good, clear direction, say at least a week out from the deadline. But you know, I've worked under tougher time frames.
That's
Thank you, Worship. I'll take your guidance on this, but I would like to ask whether it's permissible to get a feel for the sort of dollars that would be involved in terms of cost to take this case to the Environment Court, whether that should be a matter that the public should know.
And this is why we're going into confidential, so we'll carry that question over into our confidential deliberations. That may help us. Councillor Gould?
Yeah, thank you, Lachlan, for your report. Was there any mention of the time frame of the development? Are we talking 1 year, 2 years, 5 years, 10 years, 20 years?
No, we didn't have any real evidence of commitments around actual development. What I can say is that there's two points I'd raise. The first is that looking at the nature of this development and the infrastructure that is required to open it up for development, we're talking about long lead-in time. So I suspect that if they were to commence immediately, we'd still be some years away from an operation occurring on the ground. So there's significant infrastructure constraints which will drive those timeframes. The other thing is that the total land area of the plan change area is some 240 hectares. So this is a development that will just continue to break new ground over probably decades, I would suspect. And the other thing I think is probably just relevant to the question is Quayside has made it very clear that they won't ultimately be the development company. They are securing the plan change, securing the planning framework, creating the opportunity, and then they've made it clear they won't be a land development company. So you can expect to see property within the plan change area bought and sold by land developers.
And I have a question. Can you explain the capped area? Because there have been other industrial developments with capped areas. Can you give us a little bit more explanation about the size of the cap?
Well, the footprint area is relatively small. If you think about a 240 hectare total plan change area, the area for the offices and community facilities is 2.6 hectares, so it's very small in relative terms. But bear in mind that with industrial development, and particularly the kind of development that's anticipated here, which is going to be about logistics, you know, we're talking about an area which will support the Tauranga port in terms of a footprint. So it will be footprint hungry. So you can expect activities which, you know, a single activity could take up a very large area of land if it's you know, logs or raw materials and so on and so forth. So in relative terms, that community facilities area is quite small within the plan change area. But as I say, BOFers have done some modelling about what you could produce under the rules, and when you compare the potential floor area of the offices in the 2.6 hectares to some of the office areas in other centres, like for example Te Puke, you start to get some context about how big this could be. And I think the other point I'd make there is that the office and retail activities within the plan change area were designed to be scaled and to sufficiently meet the needs of the plan change area, not to necessarily create a catchment well beyond the plan change area. And our concern is that without necessary constraints, it will potentially have a catchment much wider than simply the business park.
Supplementary to that, really, because I'm not aware of the Western Bay approach, but is this in line with their approach to capped areas within industrial development? Is this the same? Is it being treated the same as all of their other developments?
Look, I'm not in a position to give you a range of comparisons, but I do know, for example, that there are constraints on these kinds of land use activities in other industrial type areas, for example Tauriko in Tauranga City, where caps are created. So, and in my experience in other parts of the country, you would expect to see caps so that intended land use activities retain the kind of scale that you expect when you create the rules.
Okay. Councillor Hunt.
Thank you, Lachlan. Yeah, just following on from that, I wondered whether, is it reasonable to make that assumption on that 2.6 that even if it was a single story, it would be approximately 10,000 gross floor area? That's one question. And the other is there an example, and you've said that you're not sure if there are, of a 2.6 hectare site, so that we can get our head around, is it something like the base, is it something like North Harbour, just anywhere around the country where we can visualise what that means? Because while it's small within the 240 hectares, it's still 2.6 is still a large piece of land. The footprint, as I said, the footprint itself, 2.6 hectares, is to use your example of the base, significantly smaller than the base. The base is more like 16 hectares. Okay, so it's much smaller in terms of its footprint, but it doesn't have constraints in terms of how many levels you might go to. So again, you know, with clever development and multi-story type development, you can get up to the sort of numbers that we've talked about. As I said, BOFers, the modelling they did was 2-storey, and that was where they came to the figure of potentially 20,000 square metres. And look, there's, you know, as many iterations of that as you care to imagine.
Bentley, then Councillor McVicker, then Councillor Stewart.
Thank you, Madam Mayor. Lachlan, thank you for your summary today. In your opinion, or do you have an opinion as to Quayside's involvement? Do you think it's possible that they're very keen to see this go ahead due to the fact that they've got an awful lot of very valuable land in Mount Maunganui, which hopefully this development will free up as a staging post for the port.
Yes, I mean, look, I'm speculating in terms of the commercial drivers, but I think there's two things that are driving Quayside's decision making. First is, yeah, as you said, valuable land and a valuable footprint at Mount Maunganui, which is going to experience growth pressures. So this is a pressure release valve in that sense. And the other thing is that Quayside has already invested in this land out in Rangiuru, so it's got holding costs. It's holding this land currently, and it will enjoy a significant value uplift once the infrastructure is in place and the business park is operative. So I think those would be the key commercial drivers sitting in behind it.
Councillor McVicker.
Thank you, Your Worship. Lachlan, my simplistic view of the environmental court is that you cannot necessarily take an economic argument to that court. Can you just elaborate as to the overriding ramifications that incurs?
So often we talk in the Environment Court about trade competition effects, and that's principally this economic issue. And you're quite right, in the Environment Court, trade competition is not an effect that the court is concerned about. So the impacts of a development on the competitiveness and whether someone's till stops ringing is not an environmental effect that the court will look to deal with. So when you are concerned about economic impacts, you have to demonstrate effects which go beyond simply trade competition into material environmental effects. Now the Court of Appeal has probably still the most effective pronouncement on this, and it gave the example of you've got to be able to demonstrate something more than a till not ringing anymore. You have to go beyond that to say, well, the impact of this proposal on this centre was that the tills stopped ringing, the patronage and the people stopped coming, the bus route became unviable and stopped running, and some of the public services that were on offer in that centre started to drop away, and to take the extreme example, the tumbleweed started rolling through the main street. Now that's an extreme example, but that's the kind of environmental effect that the Environment Court would be concerned about and is prepared to deal with. Simply, I used to have a till that was busily ringing and now it's a little quieter than it once was, is not an effect that the Environment Court is concerned about.
So the ramifications of what you just said on Rotorua, where do you put us in relation to a scale of 10? What chances?
I wondered there, Councillor McVicker,
We're
that's
going into
getting very near to what
Okay.
we need to discuss freely and frankly and confidentially.
I'd just like to get a feeling as to where we...
We'll just
so I
carry
understand where you're
that
coming
over.
from.
So that's costs from Councillor Kent and the impact. Councillor Sturt.
Thank you very much again, Lachlan. In terms of demographics and population growth and port development that's going to occur, which not the regional council as landowners of this block, but certainly the Port Authority and the Tauranga District Council, in conjunction with the Western Bay District Council, have signalled that that's going to occur. Is this 240 hectare development seen as complementing those objectives in terms of port development? Because, I've read the decision from Covered, and there's a lot of lines for it, right, left and centre, and a lot of changes. But are we being head in the sand in the terms of the long-term development of Western Bay as an entity with the population growth that they're envisaging? Are we head in the sand in terms of trying to make it as a restrictive activity as we can? So there's a number of questions there. Maybe some of those should be in confidential, but I'll be judged by your answer.
Lachlan, could you put your mic on? Thank
Sorry.
you.
But there are some aspects of it that we say need fine-tuning, and that was what we were focused on at the hearing, and it were the three elements that I identified at the outset.
Put your mic on, please.
Sorry, Madam Chair. In light of the 240 hectares, and there's considerable land surrounding it that's undeveloped, does this mean that we could have sort of a shift and an opportunity for more housing and light industrial development close by? Because I think that's one of the areas that concern is coming from the Tauranga people, that there may be another major industrial park adjacent to this, that this is the start of a long-term development plan.
I'm not going to be able to answer that definitively. What I can say is that the plan change that we're dealing with, PC72, does not provide for any residential land use. It is all industrial and business related. Whether there is aspirations for residential in those surrounding areas, I'm not sure. I suspect so, and the reason I say that is because I know that one of the parties that was interested in this plan change and submitted in opposition was a very large land development company, Blue Haven, which is developing south of Papamoa towards Rangiuru, and within their development aspirations there is a significant amount of residential land use.
I suppose the question on the public domain is, why should Rotorua be worried about this?
Yes, and I think that's a good question, obviously, and the reason is simply this: you have invested a significant amount of public funds in your infrastructure, and you have land capacity available, and you have an economic interest and a public interest in ensuring that that land is efficiently used, and in fact so too does Bay of Plenty Regional Council have an interest in an efficient and sustainable use of the resources throughout the region. If we enable development to occur which leads to inefficiencies in terms of the provision of public infrastructure, inefficiencies in terms of available land, that is not the best use of our resources and is contrary to the Resource Management Act and is something that the Environment Court would be interested in. And that's principally what has driven the thinking behind having a voice in this discussion to date.
What drove us to engage in the first place. Are there any further questions before we move? Councillor Rokoatate.
Yes, thank you, Madam Chair. I've actually enjoyed listening to this discussion, and I'm sure those in the gallery and possibly on the live stream will have as well. What I wanted to ask, the reason for going into confidential is because perhaps we might appeal, because when I've just heard you say, Your Worship, that our citizens might say, well, why are we concerned about this? The fact is that if they could hear what we're going to discuss in confidential, then they may really get a sense of why we are actually concerned about this. And so I'm just trying to get a handle on, is it because we might appeal? Is that the reason basically why we're going into confidential?
I think we'll have many more sensitive commercial questions to ask in confidential. It will be on the public record when we make whatever decision and our reasons for that decision. But those commercially sensitive issues are something that we should put in public excluded, in my view.
Thank you all. I just hope that will be then the tenure of our discussions, because if it's not, then I would have liked to have. I just think this is really important. I've enjoyed the discussion, and that sort of thing. I understand there might be a few things, but I think our citizens would really applaud the fact that we are taking a stand on this, but they're only going to get half of the information at this point.
About what our action is, and that's why we'll go into confidential, and that will be on the public record and the rationale behind it. So do I have a mover to go into confidential, please? Councillor Hunt, a seconder. Councillor Wepa. All those in favour, please say aye. Contrary? Carried. And we'll just have a 2-minute break, thank you, while we... Yes. Donaldson?
Is the additional point that Lachlan be permitted to remain during confidential?
Absolutely.
So
Yeah.
I'll
And
move,
that
I'll move
Lachlan remain. Yeah. Thank you, Lachlan. You can keep sitting there.